Good morning in the UK and good evening in Australia. My name is Joanne Holland and I'm the CEO of the Australia-UK Chamber of Commerce. Delighted today to introduce MHA and Freeze. More about them in a moment. Now, there's never been a better time to start up business in the UK. The UK ranks in the top 5th largest economies in the world, and it is the one most open for business. While there are labour shortages in some sectors, the UK remains an economy with a huge talent pool. It has a very flexible labour market. There are few barriers to doing business in the UK. And the UK is hungry for new trading relationships. And this was evidenced in the speed with which the UK and Australia entered a free trade agreement in record time. The FTA will allow Australian companies to bid on UK government contracts and vice versa. Recognition of professional qualifications and ease of movement of people between the two countries will positively impact both economies. Trading between the UK and Australia will be much easier, and there'll be a huge trading and service opportunities. And the FTA between the new countries provides a segue for the UK to join the Trans-Pacific Partnership, allowing it to trade with Asia. Companies trading in the UK are expected to have direct access from the UK now to Asia. The AUKUS, the UK-US Defence Alliance, is another positive step between the two countries. There are compelling reasons to set up for business in the UK, and today we'll hear from the experts who will speak about how to expand into the UK. MHA and Freeze are both UK members of Baker Tilly International. MHA are a firm of chartered accountants, tax and business advisors, and have offices all around the UK, providing a full range of business services to enterprises and individuals. Freeze is a top 50 full-service commercial law firm with offices spread around the UK. And we have two speakers today, Chris Denning and Kevin Poulter. He's no relation to the golfer, Poulter, I might add. Chris Denning is the corporate and international partner of MHA. He has over 27 years tax experience and joined MHA in January 2013. Previously, Chris spent nearly 20 years split between PwC and latterly KPMG. Chris has provided a comprehensive range of advice and expertise for a range of corporate clients, from entrepreneurial-owned startups to large corporates and multinationals. This includes advising on mergers and acquisitions, group restructuring, inbound, outbound expansion, CFCs, PEs, shareholder planning, employee incentivization, transfer pricing and compliance, and profit extraction and repatriation. As well as extensive transactional tax experience, he proactively identifies issues and opportunities for tax planning, which can be aligned with commercial goals and activities. Welcome, Chris.
Thanks, Joe. Thanks very much. I think I need to update my CV because it's actually 32 years, not 27 years, but I'm sure we can resolve that. So thanks, Joe, and thanks for inviting us to speak today, and welcome everybody. So clearly these are very exciting times following agreement of the UK-Australia trade deal, and today we're going to look at some of the practicalities for Australian corporate groups who are considering expanding their operations into the UK. So Millie, can you bring up the agenda slide, please? So in terms of the agenda, we're just going to spend a minute or two just looking at the economic environment in the UK. Then we'll consider how a corporate group might conduct its operations in the UK, and then look at the general tax environment, and finally touch briefly on the audit and reporting requirements. So next slide, please, Millie. Thank you. So I think it's fair to say that in normal times, we're talking about a very stable economic and political environment in the UK, which makes, as Joe has said, which makes the UK a great place to do business. And the expectation, I think, must be that we return to some degree of normality in the near to medium term. I think the points I've listed on the slide are self-explanatory, and I'm assuming that most people attending today will have already done some commercial due diligence on the viability of the UK market and may have already decided that it's a place in which you'd like to do business. So in the interests of time, I'm not going to comment any further on these points, though I will just touch on the attractiveness of our fiscal regime. So in very broad terms, we have a number of measures to try and encourage investment into the UK, including, and these are just examples, so it's not a full comprehensive list, but we have a very favourable R&D tax credit regime for both SMEs and large corporate, mainly attracting interest as far as our tech, pharma and bio sectors are concerned. We have a 10% patent box tax regime where patented products are sold, or products with a patent are sold, are taxed at a 10% tax rate. We have a tonnage tax regime. We have an enhanced capital allowance regime at the moment, where we get a super deduction of 130% of capital expenditure. That's a relatively short-term measure, but it's been extended as a consequence of COVID and various other events. We have a very competitive holding company regime. So in the UK, we have a participation exemption for disposal of shares via a holding company called the substantial shareholders exemption. We have a dividend exemption. We have no domestic withholding tax on distributions. And the UK is part of a very extensive global double tax treaty network. I think it's 140 odd countries where we've got a double tax treaty in place with. We have our own REIT regime, real estate investment trust regime, to enable profits from a property company to be distributed directly to the shareholder, taxed at shareholder level as opposed to a corporate level. And we have various investment incentives, such as EIS, SCIS and VCT, which provide tax reliefs, income tax reliefs for investors on the way in. So that if you invest in an EIS scheme, for example, you get a 30% tax deduction. You can invest up to £2 million. You get a 30% tax deduction up front, income tax deduction, and your exit, hopefully a successful exit, there's no capital gains tax on disposal of the shares. So that's very attractive. And another reason why lots of companies want to come to the UK capital markets and funding markets to try and raise money to fund their businesses. So just a general feel about the regime in general, just to give you a flavour. So Millie, next slide, please. Okay, so if you've decided to expand into the UK, what's the best way to go about it? Well, I guess the start point would be whether there's an intention or indeed commercial requirement to actually create a physical presence in the UK. If not, then the first step, and it may be more appropriate, might be to initially appoint an independent agent through which goods and some services, software services, for example, could be sold to UK customers. I think that this would certainly enable a group to get an initial feel for the UK market without the costs and commercial risks of establishing its own presence initially. If, however, a decision has already been made to put boots on the ground, so to speak, that is to employ people in the UK, the next question is whether this creates a UK permanent establishment, stroke PE, of the employing company. So broadly, a UK PE is created where a business activity is carried on through a fixed place of business, for example, an office, which can include office space at a client's premises. I think it's also possible to note that an employee's house can be a fixed place of business where it's at the disposal of the employing entity. So, for example, where a house is being used or promoted as the UK business or contract or contact address, sorry. That's always one to watch out for if you've got employees in the UK and they are, for example, using or giving out business cards with their home addresses under the company banner, that can point to the house being a PE of the employing entity. I think it's fair to say, because when we get asked this question all the time about whether a PE is created, but the question as to whether there is actually a fixed place of business and whether a business activity is being carried on through it can be quite ambiguous in lots of situations. But where a PE is created, the overseas company which has created it will need to register as a UK branch for UK tax purposes with HMRC, and as a place of business for UK company law purposes with Companies House. And a corporation tax, an annual corporation tax, will need to be filed with HMRC, and the parent. And this is an interesting point which we'll come back to later. The parent company's accounts need to be filed with both HMRC and Companies House. And just to clarify, I think at this point, in terms of what constitutes the public domain, what you file with HMRC is not in the public domain. What's filed with Companies House is in the public domain. So that's just one thing to think about in terms of, well, we'll come on to branch versus limited company later, but it's just one of the points to think about. So the alternative, once you've established a PE and set up a branch, is to consider, and the UK, I think it's fair to say, is relatively straightforward in terms of entity choice. We do have limited companies, and we have unlimited liability companies as well. I'm not going to talk about unlimited liability companies because they're so rare. And for me, the whole point of having a limited company is you have limited liability. But essentially, if you're a corporate coming to the UK, you've got effectively two choices: one being a branch, and the next being a limited company. And it is possible. Saying that, I mean, there are a number of differences between the two, and it's relatively common, I think, for an entity, for a group coming to the UK to start with a branch presence, which then incorporates into a limited company. And this can be done on a tax neutral basis. However, when I advise my clients who've already made the decision to invest or start in operations in the UK, I usually advise setting up a limited company at the outset rather than a branch as an interim step. But as I said, there are a number of differences, but also similarities between the two. And I've actually got a comparison table here, which extends to 3 pages, and I'm not going to go through that in detail. But some points to note are, I think, in terms of setup costs, a limited company is actually cheaper than a branch. And that's mainly because in lots of situations, certainly for non-English speaking companies coming to the UK, they have to file, if you set up a branch, you have to file your articles, and where they're non-English drawn up articles, they need to be translated into English, which can be quite expensive. I think in general terms, the administration costs of a branch are lower than a company, and that's mainly due to whether or not an audit's required, which we'll come on to at the end. But in general tax terms, the position is broadly the same. So the corporation tax rate for a branch or a company is the same, at currently 19%. I'll come back to that later. If you're a branch from a UK transfer pricing perspective, you treat the branch as a separate entity for transfer pricing purposes. So the arm's length principle applies, in both a branch situation and a company situation. And I think it's fair to say that in general terms, the amount of tax you'd end up paying in the UK, or sorry, the UK taxable profits, which would drive the amount of tax you pay in the UK, ends up being broadly the same, whether you're a branch attributing profits or whether you're a company. And certainly we would look at it from a transfer pricing perspective to get back to broadly the same result. And fundamentally, it spins on functions, activities, and risks being undertaken by either or. So notwithstanding the last point in terms of profits being broadly the same, I think one of the key differences between a company and a branch is that a limited company, its profits are ring-fenced within the limited company itself. Whereas if you're a branch in the UK, I mentioned earlier this issue around the obligation to file parent company accounts. So if you're a branch in the UK, you have to do a branch tax return and file the parent company accounts. So HMRC will have visibility over the full results of the company. And that could, in certain circumstances, encourage them to look a bit further or look into a bit more detail about the profit attribution. Say, for example, a branch was showing a relatively low return or a low margin on product sales. and the group as a whole at a significantly high margin, that the fact that you've got to make additional or more disclosure in relation to the overall activities or profitability of the overall activities might make HMRC look at it in a bit more detail, which is again often the reason why people go straight to the limited company option as opposed to a branch. And the other thing, I guess, just to mention from a planning perspective is again what I mentioned, that a limited company's results are in the public domain, but it is possible to have a sort of hybrid structure where you might end up with an offshore company subsidiary of an overseas group whose only activities that the UK branch. So, for example, if you used a Jersey company whose only activity was that of its UK branch, you still have to file a UK branch tax return. You still have to file the Jersey accounts in the UK, that i.e. to HMRC, not to Companies House. But that would be it. There'd be no obligation to file Jersey accounts with Companies House. So in that example, you might get less exposure if that was something that was important to you. So in terms of setup and registration, it's relatively, in fact, it's very easy to set a company up. It can be done in 24 hours. We just need details of the shareholders and the directors, and just some personal details around the directors themselves. And it's relatively, as I mentioned earlier, it's relatively cheap to do. It's sort of £300 to £400. As I say, a branch could take a bit longer because of the articles issue. In terms of capitalisation of a company, so there's no minimum level of capital or share capital required for a company. So if you wanted to, you could set up a company with a single share issued nominal sum. In practice, however, you're always going to need, there'll always be a working capital requirement. So some funds will need to come in either by way of equity, debt, or a mixture of both. And clearly transfer pricing will impact this decision, which I'll touch on later. But one of the things that people used to think about in terms of the mix was that up until a few years ago, share capital, well, in fact, it's still the case now, but it's an easy fix. So share capital stroke share premium reserves aren't distributable. So groups used to prefer debt because when the company was when the UK subsidiary was in a position to repay, it was easier to repay debt. So that would be a driver in terms of the debt equity mix. I think it's fair to say now that that's less of an issue. Our company law rules changed a few years ago, and it's much easier now to do a capital reduction in order to repay share capital. So it's now less of a problem. Albeit though, I think commercially, group may still want to present something in the face of it, a stronger balance sheet from a share capital perspective, which might drive having more equity than debt in certain situations. In terms of where the directors need to be, so there's no statutory requirement for a limited company to have UK resident directors, but one of the key practical issues that I mentioned now, as far as groups coming to the UK will have, is actually establishing a bank account. It's probably a separate session as to why that's so difficult, but having at least one UK director in that situation can, I've put up the process, but I think it can ease the process in certain situations. And I guess the last point is in terms of trading premises, just as a practicality. So in a branch structure, it would be the company, the parent company itself entering into the lease contract, and therefore subject to the obligations under that particular contract. And you might think, well, if I've got a limited company, the parent company is not necessarily exposed to that. But I think in practice, the landlord will always require either an undertaking or a rent guarantee from the parent on behalf of its subsidiary. So I think in summary, where the decisions have been made to start the business in the UK, in most situations and most groups start with a limited company at the outset to trade through and take it from there. So Millie, next slide, please. Thank you very much. So next we're going to look at how corporate entities are taxed in the UK. And as you can see, there's a long list of points which could be discussed in some depth, but we've not got time now, so I'll try and rattle through these, and I'm happy to take questions at the end. So we've already touched on the political and economic instability at the outset, and one of the things that is up in the air at the moment is the increase in our corporation tax rate to 25% from 1st of April next year. Now that's currently in legislation, but may or may not happen. So that might be reversed depending on who wins the Conservative Party leadership contest at the moment. I think 3 of the 4 candidates have already said they're going to I think they're going to retract that increase. So it remains to be seen whether that turns into reality. So in terms of administration, so a corporation tax return needs to be filed within 12 months at the end of the accounting period to which it relates. So for example, a corporation tax return for 31 December 21 or for a 31 December 2021 accounting period will need to be filed on or before the 1st of January 2023. And the payment dates vary depending on the size of the taxable profits. So if taxable profits are less than 1.5 million, then corporation tax needs to be paid 9 months after the year end. For profits above 1.5 million, corporation tax needs to be paid in instalments starting in the current accounting period. And there are 2 different instalment timetables depending on whether profits are below or above 20 million. So for very large companies, they start paying instalments much earlier in the current accounting period. It should be noted that the profits limits I've just mentioned are for the worldwide group. So you don't just look at the UK subsidiary in determining whether those limits apply. You would need to divide that by the total number of active companies in your group to work out whether you're in the 9 months payment period or whether you're in instalments. So for example, if you had 10 companies in the group, that 1.5 limit would be divided by 10, so it would be 150,000. So if your subsidiary in the UK generated taxable profits of 150,000, it would be in an instalment regime, not in a 9-month post-year-end regime. So to work out taxable profits, which is the basis on which you pay corporation tax, the start point is always the profit before tax in the accounts, and this is then adjusted for various items such as depreciation, capital allowances, entertaining, legal fees, general provisions, etc., to get to a trading profits amount, which is then adjusted again for finance costs, losses, brought forward, and so on, to get to it's called a PCTCT, profits chargeable to corporation tax. So just touching on finance costs, so the UK has probably been at the forefront of implementing some of the base erosion and profit shifting measures that the OECD proposed and have proposed over the last few years. And one of the things that came out of that was a corporate interest restriction. So we do have our corporate interest, if I can say it, a corporate interest restriction regime, which broadly means that for interest payable up to net interest payable up to £2 million, there's no impact, there's no restriction on that being deducted against your PCTCT. But for interest payments over 2 million, the amount deductible is restricted to 30% of what's called tax EBITDA. And again, it's probably a separate session to explain what that is in more detail. And it's also possible to look at your ratio, your debt to profit ratio for the group as a whole, which may give you a more favourable percentage deduction. But just to say, so we do have the CIR rules, and they do impact some of our larger clients with larger funding requirements in the UK. So just going down the list, I've already touched on fiscal incentives, so I'm not going to mention those again now in any detail. In terms of chargeable gains, UK resident companies are subject to corporation tax on chargeable gains at the same corporation tax rate as that on trading profits. But for most groups, for most trading groups, however, where shareholdings are sold, I've mentioned this already, any gain on disposal would normally fall within our participation, our SSE regime would apply, so it would be exempt. And I think, you know, in most of our situations where we see gains, it's typically in relation to the disposal of a subsidiary or one of the group entities. So in practice, most gains would arise on the disposal of UK real estate. Non-resident companies are subject to corporation tax on chargeable gains in connection with chargeable assets used for the purpose of a trade. So going back to our branch scenario, if we've got a branch of an overseas company carrying on a UK trade and it made the disposal of a chargeable asset, say a freehold property, which it used for the purpose of its trade, then that would be subject to corporation tax. However, non-resident companies are also subject to UK corporation tax on gains on the disposal of UK real estate generally, or assets deriving their value, which is 75% or more, from UK real estate. So for example, if you own shares in a property investment company holding UK real estate assets, a disposal of those shares can bring a non-resident company within the charge to corporation tax. And I think it's fair to say, and this might be a slight aside, that the whole fiscal regime around the taxation of non-residents holding UK real estate interests has changed significantly in recent years, is now far more complicated, and I think it's fair to say is less advantageous than previously for non-UK resident property investors. So if that's a sector you're looking at, then please come and talk to me about that, because as I say, that whole regime is a bit more complicated than it was previously. In terms of losses, we have a relatively flexible loss regime. We also have group relief. So if you've got 2 or 3 entities in the UK as part of your group, then losses could be surrendered between group entities where there's profit capacity. In terms of an individual company incurring losses, those losses can be carried forward and used against future profits. I guess one point to note when we start making lots of money is where taxable profits exceed 5 million, only 50% of excess profits can be used to set against carried forward losses. And I mentioned R&D tax credits earlier, so our SME R&D scheme enables an additional deduction of 130% of qualifying expenditure to be claimed. And where this actually creates a loss, the loss can be surrendered for a tax repayment equivalent to 14.5% of the loss surrendered. Now, again, that's quite a favourable regime. You know, that 14.5% is part of the funding mix for many, certainly tech, software, pharma and biotech companies. The SME repayment is part of their overall funding requirement and funding plan. So in terms of transfer pricing, and as I've already mentioned, the arm's length principle will apply from a transfer pricing perspective. But in the UK, we do have an SME, small and medium size company exemption, where there's, from a UK perspective, where you're an SME, there's actually no obligation to transact on an arm's length basis on transactions between qualifying treaty territories, which essentially is a treaty between the UK and a country which has a non-discrimination clause in it, and HMRC have a list of those territories, which would include Australia. And an SME, for this purpose, is set out, or is, in terms of its limits, is set out as in the EU's SME definition. Now that sounds great, but in most situations, the other side of the coin is that the company being transacted with isn't subject to an exemption. So in most of our situations, in fact, in virtually all of our situations, we're still advised and we're still looking at intercompany transactions being conducted on an arm's length basis. So in terms of dividends and profit repatriation, I've already mentioned that we don't have a domestic withholding tax on distributions, so profits can be repatriated by way of dividend with no additional tax suffered. I understand that from a reciprocal basis that dividends from subsidiaries in which a 10% holding or more is held or exempt from tax in Australia. So that means at the moment, UK profits could be rolled up at 19% and distributed back to Australia with no additional tax. So that would give an effective tax rate of 19%. I mean, clearly there are other ways in which profits could be distributed, more traditional ways, such as intergroup charges, management fees, interest and royalties. Although again, I understand that the Australian corporate tax rate is currently higher than the UK. It's either 25% or 30%. So I think using those types of methods are unlikely to be preferable at the current time. So we do have a withholding tax of 20% on interest and royalties, subject to reduced treaty rates. And again, just to note from a practical perspective, where you're relying on a reduced treaty rate for interest purposes, it's not an automatic claim. You have to get advanced clearance in advance of making an interest payment in order to apply that rate, which isn't the case for royalties. I think you just have to be satisfied yourself, if you're paying to a recipient in a particular territory, that they're resident in that particular territory for tax purposes in order to apply a reduced treaty rate. So in most cases, unless exempt suppliers are being made, there will be a requirement to register for VAT. And generally, VAT returns are filed quarterly, which is now done electronically via HMRC's Making Tax Digital initiative. And finally, there are various issues around employment taxation, including the requirement to register and operate a payroll, provide a minimum level of pension benefit, and deal with other incentives and benefits, some of which Kevin may touch on in his session shortly. Thank you, Millie. Can we move to the last slide, please? So I'm just conscious of time. So I'm not going to say much about this particular slide. I think the key point here, the key points here are that branches, as I've already mentioned, do not need to file branch accounts with company sales, but branch accounts will need to be prepared for HMRC, on which the corporation tax return is based. However, the parent company accounts will need to be filed with both HMRC and company's house. And I guess the key point here, which I alluded to earlier in terms of costs, is that all UK companies require a statutory audit subject to the exemptions that you can see. So you've got a turnover limit, asset test, and an employee limit there. And I think in most situations, people coming to the UK will fall, when they're establishing a business in the UK, will fall within those limits. But it's the same as the test for corporation tax payments. The test applies to the number of companies in the worldwide group. You have to look at those tests on a worldwide group basis in order to determine whether an audit's required. So you can end up in, and some of our clients don't really believe this, in a situation where you can have a pure startup with relatively little activity in the first year, needing to be audited. So that's just one of the things, I guess, to watch when you're thinking about the branch versus company equation. It's just one of the things to factor in. So hopefully, hopefully that's given everyone a flavour for the sorts of issues and regulatory and administration requirements there are for establishing a business in the UK. I'm happy to take questions at the end. So in the meantime, thanks for listening, and back to you, Joe.
Thank you, Chris. That was excellent and comprehensive, and we'll I can see questions now coming from the audience. I'm now going to introduce Kevin Poulter. Kevin leads the employment team at Freeth's London office and has over 20 years experience in advising a broad range of commercial and corporate clients, charities, non-for-profits and senior executive employees on all aspects of the employment relationship. He regularly advises companies on establishing and scaling businesses new to the UK, and he's instructed to negotiate terms of senior employee termination and exit arrangements. Kevin was the inaugural host of The Hearing, a popular legal podcast produced by Thomson Reuters, and he's a regular contributor on employment and social media issues to local and national press and broadcast media, and writes regularly on topical legal stories. He's contributed to several books, including most recently Doing Business After Brexit, A Practical Guide to the Legal Changes, and it's published by Bloomsbury. Welcome, Kevin.
Thank you very much. Hopefully, I think we're on. Yes, I think we're good to go. So let's get straight into it. Hello, everyone. Thank you, Joe. Let's crack on through. We'll go straight into the next slide and talk about employees. Now, whilst you've set up in the UK, or maybe you're still considering it, but let's think about what the options are. And there's a lot of detail on the next few slides. I don't propose to go through all of it. But it's there for you to go away and have a look at after the event, and indeed get in touch if there's any further questions. But most companies will naturally employ people directly. It's perhaps the most sensible and logical thing to do, but it's not the only option. And permanent employment certainly is not the only option available to employers in the UK. So by far and away, most people are employed directly and employed on that full-time permanent basis, but also consider options. And the way that the pandemic has allowed people and opened up opportunities for flexible working, agile working, developing their own businesses, perhaps even alongside working for an employer directly full-time. But part-time employment is increasingly preferred by employees, if not necessarily always by employers. And believe it or not, there is no automatic right to part-time work in the UK, or to request the part-time work and to be guaranteed it. But there are limited exceptions for denying it, refusing it. So something that's worth thinking about, and when you're setting up perhaps initially, whether that's something that you would open up and offer to employees initially. Think about fixed-term employment as well. So if you are, for example, prepared to put your foot in the water for maybe 6 months, a year, even 2 years, fix the employees into that period of employment. It can be a double-edged sword. It works both ways, and maybe an expectation that either their employment will continue for that length of time, which we can work around, or indeed that it will automatically end at the end of that period, and they've already got something else to move on to, even if you want them to continue. And I'll touch a little bit more on that shortly. Depending on the sort of business that you have as well, what we call casual is frequently referred to as 0 hours employment, where there's no fixed hours, no fixed sort of working pattern necessarily, and employees can come and go. And typically, one example of that, for example, is working on catering and hospitality, where you might be servicing weddings, which don't happen every day, but happen from time to time, not even every weekend. So bringing people in, a flexible workforce, again, works both ways. As much as you might not offer work to that employee, they may refuse to work for you, and you can't really penalise them on the back of that if they don't have those sort of permanent employment rights. Chris mentioned briefly as well about agency operations and developing, maybe even scouting or sourcing work initially through an agent. Agency workers, absolutely, they can sort of keep an arm's length from that employment relationship and hold you back some way from stepping immediately into being that employer and all the obligations that come with it. Something to think about, and something that would be worth considering, particularly if you're looking to scale up quickly and bringing in a lot of workers in a short time period where you don't necessarily have the opportunity to go out and do the recruitment drive yourself. And I've touched on here in relation to freelance consultants, contractors. And this is something which the government is taking some real steps towards addressing and formalising in some way. And there's a piece of legislation we call the IR35, which if you do set up over here, if you already are, you're perhaps familiar with. And it takes really to the heart of the relationship, whether these people are engaged genuinely as self-employed workers, or if they are essentially employees just wearing a bit of a disguise and a different title, a different name. And the reason for that is it has an impact on who pays tax, not necessarily how much is paid, but who pays tax, and certainly in relation to their employment rights. So something that's worth considering, and I've seen one of the questions pop up already, which is about whether it's better to hire UK staff from a parent or group company or at the local entity level. And what both employment tribunals will do, but also HMRC, is perhaps have a look at what the genuine relationship is with an employee, with the employer, or with the self-employed person who might be disguised in that way, and say, well, who do you work for? And is that work that really is more likely to be employment work than not? Now, there is a tool available through the government website to make that assessment. Say if you've got any questions around that, it's both an employment law and a tax question, but certainly something we can assist with. Right, let's rattle on through the next slide. So let's say you've taken the decision to actually employ people directly. There's an obligation to have what we call a statement of terms. And essentially it's a contract of employment, sometimes also known as service agreements. And there's a specific list of what must be included in those. Now, most of the things are covered in this slide. We're running out of space and time, but have a look through that at your leisure. And primarily, I've picked out a few things underlined, which deal with, well, how much should an employee or a worker be paid? Are there any sort of specific hours and days of work? Things that an employee would expect to see. Looking at holiday entitlements, whether that includes bank holidays or not, of which we typically have 8 in England and Wales. That can expand. We had an extra one this year for the Queen's Jubilee, but broadly speaking, 8 is your typical number. The place of work Chris mentioned as well. Just because somebody is working from home doesn't necessarily mean that's not a permanent establishment for taxation purposes, certainly. Think about what that means as well, because as well as having obligations to employees, you also have obligations, obviously, to provide a safe place of work, to provide certain facilities within a place of work. And that might extend to them working even remotely, working from home. So have a think about how that operates in practice. Think about, as I've mentioned already, how long a job is expected to last for, whether there should be a fixed term employment, whether there should be a relatively short notice period, whether there are expectations around working overtime, whether there may be an opportunity to roll it over for another period without taking on that sort of permanent employment relationship. Other things in there around some benefits, we'll touch on them in a moment: sick pay, paid leave, which people are entitled to for maternity leave, for example, shared parental leave, also a right in the UK. Pension entitlements, I'll touch on shortly as well in a moment, and disciplinary and grievance procedures. Now, if you are looking to sort of step into the UK, we have an organisation called ACAS, which is frequently named in the press as being the organisation which deals with strikes and trying to resolve strikes and industrial action. But they're also there to act as a support in some ways and a guidance for employers and employees in managing disciplinary and grievance issues and other workplace disputes. I'm going to quickly move on to the next slide as well. I'm conscious of time, and just talk about a few facts and figures here. So in the UK, the minimum wage, so this is for those aged 23 and over, it does slightly reduce on a sliding scale for those over 16 years old. And £9.50 an hour is relatively low. There is an expectation that I will increase, and the targets are certainly that they'll be going up to £10, I think, in the next sort of 8 or 9 months. These tend to change and usually, so far at least, increase every year, usually around April. Minimum annual leave is 5.6 weeks, and that's something we've inherited from Europe, and is set to stick around for some time. And that's accounting for, on a typical full-time employment, 28 full-time leave days per year. Now that does and can include that entitlement to bank holidays. So that's typically 20 days plus those 8 days bank holiday. Statutory sick pay. Most employers, particularly for increasingly senior employees, will provide something more than the basic sick pay entitlement. This is very much a minimum, remember. And the rules say that if you're absent for a week, say, the first 3 days of that actually go unpaid. Now, some employers don't think that's particularly fair, and most employees would be in the same position. So they often will tend to cover at least sort of the first 3 days, if not more, on their normal or full-time rate, or even this more basic rate of sick pay, just so people aren't left without any income for a period just because they're sick. Now, depending on, say, who the worker is, sort of their status in the organization, level of seniority, that can increase, or it can stick at that level. And sometimes, again, stepping a toe in the water, starting off with a basic minimum is perhaps to be expected. If you are looking to actively recruit and to incentivize recruitment, sick pay is actually one of those things which employees are more aware of and may be more likely to question and try to get some sort of improvement on in those sort of early discussions around the pay regime. Again, some basic information. If people are on maternity leave, there's an entitlement to pay 6 weeks, the first 6 weeks of that leave period at 90% of their normal pay. That then reduces typically to a minimum, if they're presumably they're paid more than that already, but of £156.66. That extends for a further 33 weeks, taking a total of 39 weeks of paid leave in total. Now, just to touch on leave entitlements, the minimum period is actually, I think, only 2 weeks that an employee is not allowed to work after having given birth. The maximum is typically 12 months that they would take of maternity leave. There's an entitlement for them to come back to the same job, though, within what we call the ordinary leave period, which is only 6 months. So some quirky rules around it. It may take a while to just get your head around, but say any questions that come up around that, we're available to assist. And pension requirements. Now, that was briefly mentioned again by Chris, what the obligations are around this. And there's an expectation, there's an obligation, in fact, for employers to automatically enroll employees, and the vast majority of employees, after they've been in employment for a minimum period of, I think, either 1 month or 3 months. So quite a specialist area, but we have colleagues who can guide us through this. The minimum employer contribution is 3% of their annual salary. However, there's an obligation under an auto-enrollment scheme that there must be a minimum contribution of 8% in total. Now, usually that means that an employer will pay 3%, an employee will pay 5%, but the numbers can fluctuate as long as that employer contribution doesn't drop between the 3% and there's a total of 8 altogether. Let's skip over to the next slide, just to say that these figures are all correct as of today. They tend to change around April each year, so don't come back in 2 years' time and try and get away with this. I want to talk about some pitfalls now, and these can be mainly around actually about how you treat employees in termination, and that's the main one that I want to talk about and talk through today. Again, conscious of time. Unfair dismissal. Now, what's interesting is that, broadly speaking, there are no what we'll call basic employment unfair dismissal rights for the first 2 years of an employee's employment. So for 2 years, as long as there's and I'll talk about this in a moment, not a discriminatory reason for dismissing somebody, you can pretty much dismiss them for anything, coming into work with the wrong colour trousers on, having the wrong colour socks. I don't know, I'm sticking to clothes today, but these can be, albeit not what you would assume to be fair reasons, but within the first 2 years of employment, whether it's for performance reasons, whether it's for their attendance, other forms of misconduct, they can be dismissed fairly within the first 2 years of employment. Now, there are some exceptions, and I've summarized those here. If you're dismissing somebody because they're pregnant within that first 2 years, likely to be automatically unfair, and they would still potentially have a claim there. If it's relating to trade union activity, for example, then being a part-time or a fixed-term employee, if it's relating to them sort of expressing their rights not to work over the maximum working week under the working time regulations, which is again 48 hours, another statistic to throw in there, or if you're not paying them the national minimum wage, that can be obviously an unfair dismissal if they raise that query. And finally on this list here is what we call whistleblowing. Protected disclosure is the more legal term. If somebody's raising a concern, which is that the employer is acting in a way which might be criminal, so breaching health and safety rules, and they are dismissed or treated detrimentally as a consequence of that, then again, that might bring them within that 2-year threshold and give them an opportunity to present a claim for unfair dismissal. Right, let's move on to the next slide, if we may. And what are those elements of discrimination which also would fall foul of these rules? And the list's there, and that is a comprehensive list. If you're dismissing someone or treating somebody differently, even on recruitment, because of their age, because of a disability, because of gender reassignment, marriage and civil partnership, because of, as I mentioned, pregnancy and maternity reasons, because of their race, a religion or belief. And belief here actually can be quite broad. It's a philosophical belief or a protected belief, such things to have been covered as in specific circumstances such as veganism or a belief in climate change. So bear that in mind. Because of their sex or because indeed of their sexual orientation. So they're the things not to do and to avoid. And there's an increasing movement in the UK, as there has been over many years now, around diversity and inclusion and creating a sort of a fair and inclusive workplace. And obviously addressing these is a basic start along that road. And what are the penalties? Look, if you get it wrong, what are we looking at? Well, specifically, I'm talking now about unfair dismissal, which is by far and away the most expensive and most critical claim, and the most common probably in the employment tribunals. And a basic award is essentially 1 week's pay, and that's their full pay for each year of their employment, and that's a full year of employment. So again, within the first 2 years, they would only, well, they wouldn't fall within this because they wouldn't have a right to unfair dismissal in the first place. But with a 1.5 times multiplier for each year of employment they've had over age 41. There's a cap on that as £571 a week. They're under that, then obviously that's not a minimum, that's a maximum cap. And in terms of compensation generally, well, for an unfair dismissal claim, they can be awarded up to a year's salary. Now, that's capped as well to maximum of £93,878 at the moment. That changes each year as well. But it's potentially a significant payment. There is an obligation on employees who are dismissed to go out and find other work to reduce that loss, to what we call mitigate that loss, and that compensation would reduce accordingly. And it's genuinely compensation. It's not penalizing the employer directly. It's not a penalty on the employer. It's not a reward for the employee. It's purely compensating them for their financial loss that they've suffered as a consequence of that dismissal. And I just want to touch on here on injury to feelings awards. This is something which is attached typically to discrimination claims. And where an employee might be discriminated against, regardless of whether they're dismissed or not, although if they are also dismissed, it's likely to be towards the higher end. And this is the one exception, which is, I think, considered more as a reward for the employee to compensate them in some way for this injury to feelings that they have suffered because of their treatment. And because of that, it probably could be seen as a penalty on the employer and a bit of a potentially significant slap on the wrist as well. Let's move on to the next slide. And some more practical advice around employing people for the first time. These are the very basic principles. Register with HMRC and set up the PAYE scheme, that's pay as you earn, so that employees are taxed in the right way as they go through. Liability insurance, pension scheme if required, employee contracts and policies, get them in place. They have to be provided to an employee before they start work if their employment is likely to last for a month or more. Look at the disciplinary and grievance policies, health and safety, and we have obligations under GDPR around data protection rules to make sure that employees understand and know how their data will be treated. Carrying out right to work checks, so actually checking that an employee has the right to work in the UK. And I'll talk about immigration in a very quick moment. And DBS checks, so for certain jobs, particularly where people work with vulnerable people, children or vulnerable adults, they will be expected to, you'll be expected to carry out criminal checks, what we call data, what's it called now? It's the barring service, essentially, and to make sure that they are not criminals and working in the wrong job. One thing I just want to touch on as well is about restricting employees from what they can do in the future. That's contained within the contract of employment. So if you are entering the UK market for the first time, if you are training people in what you do, sort of giving them information to price lists, actually limiting their opportunity to work for a period of time at least with a competitor, or even setting up themselves in competition with your organization, is something which should be going into the contract of employment. And again, there are rules around this. It's got to be fair and reasonable and not go beyond protecting the business, but something that we need to think about. Now, very quickly, because this isn't my specialist area, but I've spoken to colleagues about this. Immigration, onto the next slide, thank you. Have a look at this. If you are bringing people into the UK, Australia has a relationship where citizens are classed as non-visa nationals for visiting the UK, which means that for up to 6 months, they can visit the UK without a visa, and they can engage in a limited number of business activities. So that might be coming over, for example, to sort of sign up an agent, to interview people, to act on your behalf, to interview potential candidates or employees, attend certain meetings, even sign contracts. But it's not to do what we would consider as actual work within the United Kingdom. For that, you'll need to look at this system, potentially obtaining a sponsor license from the UK, from the Home Office, various rules around that. If you just move on to the next slide, please. There are certain allowances, certain schemes in place to allow mobility into the UK as well. I think just the next slide, thank you. And in very brief detail, UK expansion worker visa allowing senior managers and specialist employees of overseas companies to come to the UK to set up a branch. And I know that's one of the questions that came up as well. Looking at startup visa, so for those setting up usually innovative businesses, entrepreneurial type businesses for the first time, having endorsement of specialists in the sector as well, usually critical, and innovator visas as well, usually about bringing a certain amount of cash into the UK, but looking about business models which are both innovative, viable, and scalable. I'm very conscious of time, Jan. I'm going to throw back to you, but please do get in touch with any questions, and I can direct them to my colleagues in the right place, or answer them myself. And I've seen lots of questions coming in, so maybe we can very quickly look at some of those.
Thank you very much, Kevin, and I'll welcome back Chris to the panel. Look, we do only have a few minutes left, so I'm going to restrict the questions if you don't mind. And what we can do is please get in touch with me at the chamber, or Chris or Kevin directly, and we can direct you to the right people. So the first question we have is, Australian financial planning, tax, mortgage services are financially regulated in Australia. How do they get FCA approval to advertise, and do they need to be dual licensed?
Sorry, Joe, that's typical that my dog is answering that question. which you can probably hear in the background.
I'm sure the dog knows more about it than I do, Chris. So,
I take that. I suspect that the answer is yes. You would need to register. So we've just registered our own wealth management company. So we've been through the FCA process, and I know it's quite a convoluted process, but we would have taken third-party advice on that. So if the person that asked that question wants to drop me a line, I can certainly connect with our person that's just done ours. We also have a financial services sector that we go to market with. So we will have someone there who can give a more clearer answer as to what the practicalities are and what needs to be done in that situation.
Good. And one more question about, are there any startup grants
Shall I take that?
in the UK for?
yeah, not that I'm aware, but you tell me.
So we're actually developing a relationship with a company that specialises in grant applications. There probably isn't. Well, there are lots of grant opportunities, to be fair, and they help source or match grants with opportunities. I think most of the grant situations will be, certainly from a UK perspective, will be to support UK business. So certainly where someone has an intention to create a substantive UK presence, then there's things like Innovate UK, Horizon, which is an EU supported grant program, which even though we're not members of the EU now, we can still apply for grants. So I think the answer to that again is, depending on what you're doing, what your plans are, that there probably is and are grant opportunities available. So again, we just need to look into that in a bit more detail.
Thank you. Okay, we're out of time, but these people are available to speak to any time, Chris and Kevin. Thank you for that. Please do get in touch with them. For any further information about the Chamber, please do contact me, joanne@australiachamber.co.uk. And if you're not a member, please come and talk to me about that. Again, we thank MHA and Freaks. Have a great day. Thank you.